Okay, and happy Thanksgiving. I'm going to be talking about the Garner versus Tennessee case for this project. Um, how the graphic organizer works in this case is I have the on the left the timeline going straight up and down vertically, to the right the facts, the outcomes, and then the changes, kind of those four areas of focus. And how this is going to work is I plan to work through each level on a horizontal level, meaning moving left to right. And then as the case progresses to the next level of appeal or court, we'll move vertically downward in order to show the differences, kind of similarities and differences, the contrasts and the comparisons between the cases. So anyway, so this case is Garner versus Tennessee. It was tried by the Supreme Court in 1985, but the actual event that this civil case takes place with is on October 3rd, 1974. This young man, Edward Garner, was fleeing arrest, fleeing from police. He had evidently stolen a purse. Police were called out to investigate a burglary and to respond. He was running away and got to a chain link fence, was not able to go any further, and so started to climb the fence. Officers on the scene, including Officer Elton Himan, made a decision to use his weapon, shot Garner, and ended up killing him, shot him, and the bullet hit him in the back of the head, and he died shortly thereafter. So his father took this case in a civil case at the next level here to the United States District Court for Western District of Tennessee in 1983. So some time had passed. Now the issue of this case is a couple. It's whether police are able to use deadly force, what the nature of the threat has to be. In this case, Garner was fleeing to prevent that fleeing and to deal with the crime at hand. Can officers use deadly force in that case when they don't believe the suspect to be armed and to be a threat of further physical injury, violence, anything of that nature? That's kind of the issue. And then the Fourth Amendment issue, dealing with the definition of search and seizure, is shooting a suspect, reasonable or unreasonable seizure of that person. So anyway, his father took the case, a civil lawsuit under the Civil Rights Act of 1871, 42 U.S.C. Section 1983, in which defendants included in this case City of Memphis, Officer Hyman, the person who took the shot, and the Memphis Police Department. So this case is based on the Fourth Amendment, but also brings in sort of the privileges and immunities issues under the Civil Rights Act of 1871. The outcome of that particular case was that the district court ruled that the actions of law enforcement and Tennessee statutes to be constitutional. The reasoning was this. They said if the Tennessee statute stated, if after notice of intention to arrest the defendant, he either he either flee or forcibly resist, the officer may use all necessary means to effect the arrest. And that would lead, of course, up to and include deadly force. So the Tennessee law and criminal code said that if someone was notified that they're being arrested and attempt to flee, that the officer or officers can use any force necessary to prevent their escape, basically. Um, Now, the question is whether or not the use of deadly force was appropriate and commensurate with the crime being committed in this case, and whether or not there was a Fourth Amendment violation, an unreasonable seizure. Now, it was brought up by one of the dissenters. I'm getting a little ahead of myself, but one of the dissenters in the Supreme Court case that defendants do not have a right to flee. However, the question is still whether or not use of deadly force when the suspect is not believed to be a threat of violence and physical injury is reasonable or unreasonable according to the standard of the Fourth Amendment. So there were no significant changes between the actions of law enforcement, the initial event, and the conclusion of the civil case. The standard used by law enforcement was applied by the court, and the case were in agreement with one another. So there were no substantive changes of reversals or anything at this point. But that goes back to the next point. There is an appeal to the United States Court of Appeals for the Sixth Circuit in 1984. So it's worth mentioning that between the initial event, 1974, and 1984, we already have a decade of time. Now, that means, in one sense, that maybe the process is too slow, that justice is not being worked out effectively. On the other hand, it also means that there was more time to examine everything, and that the emotions, while not going into non-existence certainly during this time, that there's not necessarily the attention on this type of case that would be in the immediate circumstances following Edward Garner's death. So, there could be a little bit more opportunity for some objectivity there. But in either case, the appeal is made. The writ of certiorari was granted in 1984, and the court outcome was they reversed it. They reversed the ruling. The Court of Appeals reversed the ruling, holding that the killing of a fleeing suspect was a seizure by the standard of the Fourth Amendment and was not commensurate to the seriousness of the felony being committed, i.e., stealing a purse. So the decision that was made was that this was a seizure, stopping or trying to prevent Garner's escape may have been reasonable, but it crossed the line into unreasonable seizure in the minds of the Court of Appeals because of the nature of the crime being committed and the force used to make the arrest. So the appeal yielded the first major change and yielded a reversal of the results of the previous case. It ruled the actions of law enforcement and others as unconstitutional, interpreting those actions as unreasonable seizures under the standard of the Fourth Amendment. So this case ends up going to the Supreme Court. The Supreme Court, under its powers of original jurisdiction, to pull a case up to that court in order to render a decision, an opinion, a verdict on those cases. The Supreme Court doesn't majorly change substantively what took place in any qualitative sense, but they kind of reaffirm and I think add some interpretation to this case. So the Supreme Court takes the case in Tennessee versus Garner, 1985, which is how it's known now. It was a split decision, 6-2, not a 5-4 decision or something like that, where it's could kind of go either way with one person switching. So the majority of the court reaffirmed the ruling of the appeals court and ruled on the application of the Fourth Amendment, stating the in fact stating that law enforcement officers pursuing an unarmed suspect may use deadly force to prevent escape only if the officer has probable cause to believe that a suspect poses a significant threat of death or serious physical injury to the officer or others. Now, that standard could be criticized. It could, be hard to say. Well, who's to know what exactly someone will do? But for the crime, the burglary being committed, it was believed and noted that Garner was unarmed during this event. Now, the question was, could he stop Garner without by using any means to ensure the arrest, or are there limitations on that? That kind of brings in what Sandra Day O'Connor, one of the dissenting justices, brought up in this case, that you do not have a right to flee from an arrest. And, the point is taken there that how are officers to handle the idea of the fleeing suspect? On the other hand, that does not mean that it is appropriate use of force to shoot or shoot to kill necessarily just to prevent an escape, depending on what the crime is. Okay. So the outcome here, the outcome of the Supreme Court decision was significant yet limited. Limited is the word that basically all the readings that I've done seems to focus on. It was significant in that it interpreted seizure to include the shooting of a suspect who was unarmed and not expected to be a significant threat. So that puts some real life experience around the idea of what an unreasonable seizure of a person looks like. The constitutional decision made for the standard in the Garner case still left the power, however, to decide the use of deadly force to the states. So I think it's a good standard. I think it lays out some good ideas and thoughts, and it shows some significant development of thought to get to that idea of when is it appropriate. But on the other hand, I think there is something to be said for the wisdom of allowing different states and different situations to figure it out differently. I agree in this case that this use of force to the point of death by the police was inappropriate and unreasonable seizure, obviously leading to the tragic death of someone who did commit a crime, but was punished with something that was not an equal standard of justice appropriate to the crime committed. But I think there is something in the idea of states and localities determining those standards. Hopefully they apply the right ones, but the idea that a top-down solution from the Supreme Court can determine all the specifics and all the complex legal issues involved for 320 million plus people spread across a vast continent is highly debatable. But the changes. The Supreme Court didn't render any qualitative change to the decision of the Court of Appeals, but rather expanded and clarified it. The court affirmed the decision, laying out the rationale that shooting a fleeing suspect not believed to be a threat of violence was unreasonable seizure. And this decision, however, did not bring systemic changes to the standards of law enforcement in the United States. And that's not to say that those systemic changes may not be needed, but that it should be decided by 6 justices on the Supreme Court by fiat is a little bit of a precedent, I don't think, ought to be set for how the process of criminal law should be dictated in that way. I think there's too much concentration of power, but that's just an opinion. References here are laid out, explaining some of these books and different legal studies, looking back on the case, and then of course the case itself.